Senator Hicks,
Here.
Senator Ide,
Here.
Senator Cope,
Present.
Chairman Steinmetz.
Here. All right, thank you, Linda. Everyone's here. The first bill for our consideration tonight is House Bill 17, State Lands Grazing of Non-Owned Livestock. Thank you to the committee in my absence. You did great work. Thank you, Vice Chairman French, for handling that.
Madam Chairman.
Senator Hicks, did you have something?
No.
All right.
No.
All right, so we're back in business. With that, we do have a proposed amendment that we worked on for the bill. But before we get started, I had a question of the agency, if you wouldn't mind coming up. I missed a lot of discussion on this bill, but I did watch as much as I could online. And I did have just one question. And I apologize if you guys have already worked through this, but welcome back. We'll try to get you out of here this time, get you off of this bill. So my question is this. So it's my understanding that state leases are figured on how many animals, how much capacity there is, and then the leaseholder pays that lease, the state lease. And so it's paid up. So in this bill, we're dealing with non-owned livestock. So it could be animals they're running on shares that they have complete management responsibility over, or animals that, it's their grandchildren or some scenario like that. So then if that is okay for them to run those animals, like we're contemplating with this bill, why do we need extra fees or extra reporting if they have a designated amount of livestock that can run there and they don't, they paid their lease? Why do we have to document that? Why do we need anything else if we're saying, yes, you can have non-owned livestock? This is what that means, which we're defining here. What the full management responsibility would be if they have that and it's not a sublease. Can you explain to me and help me understand why we need more?
Madam Chairman, Jennifer Scoggin, Director, Office of State Lands and Investments. With me, Jason Crowder, Deputy Director. I'll start. I'll take a stab at that,
Okay.
but I may have to phone a friend here. So with my understanding of the situation that this bill is to address is third-party non-owned livestock. Let me start with saying that, as you all know, the board and the office, we have a fiduciary duty to the trust beneficiaries. And if you'll notice in, I think, sections 8 and 9 on page 2 of the bill, provides that all action upon each application shall be such as will inure to the greatest benefit to the state trust land beneficiaries. So all these sorts of subleasing, contracts, assignment situations, we have to determine inure to the benefit of the trust beneficiaries. As part of the leasing process, there is an AUM fee that is determined that has the parity ratio and consideration for contributions of the lessee to the lease. So they're essentially discounts, if you will. Well, if in fact, in these situations, it's still kind of like a sublease. In most situations, they're obtaining additional fees or additional amounts of money in order to utilize the state lands and probably their lands as well for that non-owned livestock. So they're receiving a benefit from that. Because this is a trust asset, the board and the office have to continue to ensure that the trust asset is making revenue or generating revenue for the trust beneficiaries. So if there are additional fees that will be collected to run the third-party livestock, as part of that fiduciary duty, it makes sense that we do not allow state lessees to earn a profit on the back of the trust asset, if that will. The trust beneficiary should get part of that. Now, Jason can go into the parity and the contributions aspect of this in which the existing grazing lessee is also getting a benefit that's tied into this discussion. So Jason, do you want to take it from there with that piece?
Let me just stop you there before we head to the next part of that. So, for example, if somebody's running cattle on shares, they might actually receive less benefit than running their own livestock because they just get a percentage of that. And they run it on shares, so they'll get, 60-40, whatever that split might be. So they could actually be receiving less benefit than if it was their own livestock. So how do you anticipate accounting for that?
Madam Chairman, I'll refer that to Jason, but I would just say one thing is that's why we believe it's important that the director have notification and the board have notification and knowledge of these sorts of arrangements and contracts, because all of that can be considered, if you will, when not only with respect to use of the state land, and as the fiduciaries, we should know what's going on the state land, but also if in fact there are situations where the remuneration that is being received isn't like a sublease, they're not getting a huge windfall or a benefit or something, the board can decide what in its mind might be fair, and maybe the reality is, or the decision is, that there is no additional charge for this situation. So Jason, I'll turn it over to you for the other piece of that.
Thank you, Director.
Thank you, Madam Chair. I think what you're pointing to is the complexity of the situation we're trying to tackle in a very small bill. There's a lot of scenarios that need to be thought about when we consider how subleasing occurs and how we can capture the appropriate amount of revenue back to the beneficiaries, as the director mentioned, because that's an obligation within this section of statute, but also be fair and create a sustainability situation that whoever's using that can continue to use that for the term of the lease, and that we don't overcharge and chase them out of business. That's not something that we want to do, and that doesn't make good trust sense. Not to go into the presentation that I gave last week too in depth.
I watched, so yeah.
And I appreciate that you watched, but the core message in that was that the AUM fee formula was developed with the idea of the person who signed the lease owns the cattle and is using the property. That's the only way that the formula can be interpreted, because it covers a risk that isn't there if third parties enter the equation and are covering the risk for the lessee. So in your case, or the example that you mentioned, the 40-60 split, there could be a transition of a certain amount of risk, but maybe not all of it. And as the director mentioned, that's why the office should be included to determine what that level of risk is and how much is being transferred to the third party, or the third party is absorbing voluntarily. That could have an impact on the fee as is contemplated in the amendment, that it could be prorated to a certain extent to make sure that that risk is placed in the appropriate place, either in the lessee or either in the third party livestock owner. But at the end of the day, what we're trying to do is, and we have this in an oil and gas sense as well, you're trying to use old rules and old statutes for new technology and new ways of managing leases. The formula is designed for that existing lessee. The state is covering the risk of the inputs to develop that beef. If somebody else comes in and covers that risk, there's a double benefit, if you will, to the grazing lessee that we just want to make sure that you're aware of going forward.
Okay, and then the follow-up to that would just be, we keep talking about this as a sublease, but we're trying to say this isn't a sublease, this is just, it's non-owned livestock. So I think for me, there's a bit of a disconnect there. At least that's what I'm seeing us try to grapple with, is the fact that that's probably not really a real sublease, because they're not actually subleasing the land. They have some non-owned livestock, whether it's grandkids, cattle on shares, however that occurs. So anyway, that's the thing I'm still struggling with and trying to get through this bill and figure out how to deal with it. And committee, do you guys have any further questions? Because I wasn't here, I'm catching up, but none. Yes, Senator Hicks.
Madam Chairman,
And so, Director, when I look at this, and when we look at subsection D up here, and it allows the lease shall be subject to cancellation under the current language, unless the director approves the assignment, sublease, or contract subsection, subject to the criteria established. So you have that discretion in the case of lease violations, non-payment, or whatever that criteria is, that comes back, and you have the discretion to be able to basically eliminate that lease. Now, the way I read that, and so I want to take you down to subsection 4 in the amendment. Now, we place a duty on the director, and it says the leasee of state lands whose lease authorized grazing on state lands shall not be required to obtain approval of the director. It looks to me like those are conflicts because that says shall, so you have no choice. Even in the case of permit violation, would you interpret the way that reads right now, that in the case of permit violation, non-payment of grazing leases, failure to do if the board promulgates rules and regulations, you just have to sign it. There's no provision in here the way that's worded with the shall. The way I read that, for any discretion based on any violation of any terms and conditions of the lease, is that the way you would interpret that or not? That's what I'm trying to figure out.
Madam Chairman, Senator Hicks, with respect to Romanet 4, shall not be required to obtain the approval of the director. I think a shall is a shall, and it indicates to me that there's no need to go to the director, that this could sort of go on in the background without the board or the director ever knowing it or understanding what's going on the trust land.
Yeah, and that's not my question so much as
Okay.
if in fact you were able to document that there was lease violations or even a non-payment of a lease, do you still have the ability under subsection D then to cancel that or not? And it's a legal question, but I'm concerned about that because we can't say somebody can break the rules and not follow them, but then you have to turn around and just issue the lease anyway. And that's my concern, is it's inconsistent language the way I think it reads, because it says shall. You have a duty now. You don't have a choice, regardless of what happens associated with Romanet 4. Is that an accurate characterization or not?
Madam Chairman, Senator Hicks, I try to refrain from providing legal advice, but I understand your point. I guess I would look at it as if in fact we found, some other lease violations going on, that we could in fact cancel the lease. But what I'm struggling with this too. I think it is counterintuitive because what's hard for me here is, to me, there's 3 buckets here, right? There's assignments, there's subleases, and there's contracts. This language in Romanet 4 is a little unclear because it's essentially saying, well, this isn't a sublease, so then what is it? So, okay, it's a contract, but okay, how are we going to address contracts differently than subleases? And I'm having a hard time with this because, to me, contracts, violations of the rules, all those things should still be things for which we can and should be able to cancel the lease. But this is sort of treating things differently, taking it out of a context almost. I don't know, there's not a lot of clarity in the 3 buckets, if you will. And so my legal answer to you is, I don't know. I mean, I would hope that the intent would be for the board to retain that discretion to be able to cancel any kind of arrangement or any kind of lease renewal, anything like that, if there are in fact ongoing violations and there are abuses of the land that they find out and things of that nature, or there are fees that aren't paid. I would hope that the board would continue to retain that. But I don't know with the way this is written, if a court would see it that way.
All right, Senator Ide, go ahead.
Thank you, Madam Chairman. Just a quick question on non-owned livestock currently, that I don't know how prevalent it is or how much you have to deal with that, but how do you treat that right now? How do you police that, not knowing whether they have it's non-owned livestock or not? How do you go about that? Thank you.
Madam Chairman, Senator Ide, it's my understanding that, of course, we rely on people to self-report, if you will, and we've treated it much like a sublease where we look to see what's the arrangement between the parties. Are there additional fees that are being paid in addition to whatever the rental is on the lease? But again, we're depending on the self-reporting piece, but we're treating it much like a sublease. And so therefore, if we find out things are going on and they haven't been reported and they're not in good standing with the lease upon renewal, it could have consequences. Jason, is there anything you want to add to that?
All right, any further questions? Seeing none, we'll let you go, but don't go far. You know how we are. I'm going to take the purview to bring up one of the House Ag Committee members who I know has worked extensively on this bill. Representative Schlegel, would you mind coming up and giving us your insight as to what your committee was thinking when you worked this bill and the intent of this bill?
Thank you, Chairman Stamets and the committee. As we worked this bill, well, we looked at it from the point that a sublease is if an individual has a section of state land that they've been leasing and they go ahead and lease out their whole place, then that is a sublease. But if that individual brings cattle on and is running them on his own property as well as the state land he has leased that he does not own, that really isn't a sublease. He's still just meeting the same requirements as if he actually owned the cattle, because he's only doing the same thing as he was paying the state for when he was the owner of the cattle. And so that's where we looked at it from that standpoint, that a sublease is and there really shouldn't be any extra value needed to be paid to the state because you've already negotiated that price with them. And but if you did lease out your place, say you leased it to some other owner to come in and totally manage your whole place for twice what you're paying the state or 3 or 4 times, then yeah, that would be a sublease and you would owe money to the state lands. So that's where the House committee came to on this. Just having non-owned cattle that you're totally in control of really isn't a sublease. It's just you're running cattle that you don't specifically own. And I'll stand for any questions. Thank you.
Any questions, committee?
So,
Questions?
Madam Chairman.
Senator Hicks.
So Alan, that's a little bit different scenario as I thought that we were trying to get at earlier, is some of these issues of family owned, maybe 2 or 3 different brands out there running your 4-H kids, or your cow, your son has his own little cow herd of 20 and stuff. So it's a little bit different, but in the context of what you're describing, it's not unusual for a lot of what I call yearling operators to bring in a lot of cattle, right? They don't own them, and they contract to run those on a gain, or they contract them based on a head. But those contract prices are based on them being able to make a profit off of it. Now, hopefully they make that. Sometimes I'm aware of they don't, especially on the gain. But do you anticipate that then in a scenario like that, where I bring in 6,000 head of yearlings to run on my ranch and my 3 or 4 state sections, is now would not be required, because it's not technically a sublease, that those guys wouldn't have to pay any additional funds for that for the state leases? Is that what I heard is that's exactly what you're trying to get to? Is that correct or not?
Chairman Stamets, and committee, that is exactly what we're getting at, because basically it really doesn't make any difference if that landowner's bought those yearlings and brought them in, or if he's contracted with somebody else to bring in their yearlings to raise them on gain. I mean, he's still taking all the risk for it. And I mean, if he's got 10,000 acres with 1 school section in there of state land, I mean, it's not like he's trying to take a huge advantage of the state on that one section. Doing that is the way we looked at it. And I mean, we also saw the deal you were talking about earlier, people running their family members' cattle and stuff like that. That really would as the law is now, that would be considered a sublease, so you could be in jeopardy of losing your state land for running your grandkids' cattle or whatever.
So, Madam Chairman.
Go ahead, Senator Hicks.
So Representative Slagle, have you looked at the amendment? Do we have an amendment? Because under the proposed amendment that we have now under subsection D, that scenario that we just discussed is bringing those in. It would actually allow for the state land board to go ahead and promulgate rules to require a surcharge in those particular cases that we just discussed.
And to add on to that, it's documentation too. So Representative Schlegel, just to catch you up, so there's 2 pages, and then in Romanet 4, this would be the new language. A leasee of state lands whose lease authorizes grazing on the state land shall not be required to obtain the approval of the director to allow livestock the lessee does not own, but for which the lessee retains full management responsibility to graze on the state lands, and such use of the state land shall not be considered a sublease. For purposes of this paragraph, full management responsibility includes all the duties, obligations, and liabilities as if the livestock were owned by the lessee. And then section J, for the purposes of subsection D of this section, the State Board of Land Commissioners shall promulgate rules establishing a reasonable surcharge for the grazing of non-owned livestock and requiring documentation. So for those listening online, that's the new verbiage, and I guess we take your comments on that now.
Yeah, that amendment it would be a little bit concerning to me, because I mean, as I look at it, a lot of times it's almost as much risk bringing cattle in and running them, if not more, than owning the cattle. And so when you allow the state lands office to put a surcharge on that, then you're just making more cost for the producer that's leasing the land. And I mean, and I think we've seen in the past, the state lands office has been very strict in enforcing rules that they felt were violated and vacating them and allowing other people come in and lease those properties as well.
Representative Schlegel, that was one of the concerns I was hearing from some of my constituents, is that they're very concerned that they will the land would be vacated and the lease would be vacated should they violate that, even though it's a very minor parcel in the midst of their operation. And so that, I think, was where the sentiment came, and we'll bring up Mr. Magagna as well to kind of talk us through that, because he was intimately involved into the interim committee meetings. And so I, in my thinking, I'm just wondering if J kind of defeats the purpose that we're trying to get through, and that's, then allowing more fees and more rules to document this when we're saying you don't have to document this. So those were just some of my thoughts as we were working through this.
Madam Chairman, that would be my first inclination after seeing that's exactly what this would do to the instead of clearing up the regulations we're putting on our producers now, this would just make more.
All right. Any further questions for Representative Schlegel?
So, Madam Chairman, so the current scenario is that we just described, yearling stalkers, killer cows, whatever class of livestock, you have to go through a sublease agreement. And as a result of that, anything above 50% of that profit margin, you have to remit back to the state of Wyoming. This anticipates, for those purposes, that if they can demonstrate full management, I believe I don't know what the language was, but that if they can do that, it would just be a surcharge instead of promulgated through rules rather than a 50/50 that we currently have. So you would have basically three different kinds of potentials. You've got your regular lease that you pay and run your own livestock. You got the sublease that we're talking about that you described. They just lease their whole ranch and go to Arizona and go fishing or whatever they do, and somebody just runs on that. And then we'd have this third class for these folks that are doing that, and there'd be a subcharge for that. But you think that would be objectionable to include that component in there?
Yeah, that's, I would see it. The way I see it, either you have a producer that's running non-owned livestock, or you have a sublease where they're leasing their whole place out. Otherwise, it's, most of the time, it's the producer has control over the cattle that he's bringing in.
Madam Chair.
Senator Ide.
Thank you, Madam Chairman. Yes, that, I'm struggling. I like what you're saying there. You know, you've got a section out in the middle of your ranch. You got family members that you're sharecropping with potentially, or you just make a deal with some yearlings like Senator Hicks mentioned. And then this reasonable surcharge. I mean, you're always going to have that in the back of your head. What is that? What's reasonable? Number one, and on that surcharge, everybody's reasonable is a little bit different. And if there was a formula to know what that was, so if somebody did discover that maybe you're pushing the envelope on this thing and saying, hey, you know, you can't do it this way, what are the penalties for that? So thanks for that comment. Yeah, go ahead.
All right, Senator Kolb.
Thank you, Madam Chairman. Representative Slagle, I said that right. So if you run animals on this state land, are you trying to, I guess, represent that you don't have to pay like 50% of said benefit for the state land? Because that's clearly what it has to be. And I see it being a constitutional issue to say it's less than that. So I'm a little unclear about exactly what you're representing there when you say, well, it's a little bit or it's not so much. I think that number's irrelevant to me. If it's something it has to be covered. And I guess want to hear why do you agree with that, or do you think it's something different? Thank you, Madam Chairman.
Madam Chairman, Senator Kolb, I guess when I look at this, it's this whole 50% you got to pay more. It's like, okay, so I have the state land lease, I'm running my own cattle on it. And if the prices go up to $2, well, hopefully $3 next year, does that mean I owe the state land half of what I get for all my calves? Right now, I owe them what we negotiated is the lease price, and that's what I pay them. So I guess my question is what is different if I'm running share cows like Senator Steinmetz said before, and I'm still only selling them the calves for the same price? I sold them for this year, and then next year the price goes up to $3 and I sell the calves. So then if we put it as a sublease when I'm running on shares, then I've got to pay more to the state. If it were just my cattle, it wouldn't make any difference from this year to next year on that. I guess that's where my confusion is. I'm not saying I'm trying to defraud the state from money that they're owed, but at the same time, I see that producers need to have the ability to make an income from the land. I mean, because it's not always profitable when you're in the livestock business.
Go ahead, Senator Kolb.
Thank you, Madam Chairwoman. So Senator Kolb doesn't run cats or anything on his property. So I assumed, and maybe mistakenly, you can help me out with this, that when you enter into a sublease agreement, we'll call it that for argument's sake right now, that's done before. Or are you saying it's done retroactively? I'm a little confused about when exactly that sublease rate is fixed. Could you help me out with that? Thank you, Madam Chairman.
Well, Senator Steinmetz, Senator Culp, I guess I'm a little vague on which deal you're saying. I mean,
Well, Madam Chair,
Go ahead.
when you enter into a sublease agreement, right, with the state, is that before or after you run your animals on said state land?
Senator Steinmetz and Senator Culp, I would say that would be before. If you're actually entering into a sublease, I mean, if you say you have your 10,000 acres and you decide you're going to bring in some cattle on shares, you would have that agreement with the people you're running cattle for shares on before you get on the state land. Yes.
All right, seeing no further questions, we'll let you off the hot seat. Do the stock growers have any further comment on the amendment or the bill since we've changed it a little bit? Oh, first we need to ask other legislators. Are there any other legislators in the room? Yes, Representative Davis, come on down. Thank you for the reminder. All right,
Thank you, Chairman. Representative Davis.
welcome back.
How are you guys and commission or senators? Maybe things that might clear it up, listening to the conversation here is, are we dealing with acres or AUMs? If we spell it out with AUMs, like I have a section and the AUMs on it is 35, where other sections may be thousands of acres, or AUMs, So I don't know if we can tie some of this verbiage into an AUM, and a 50% additional cost per AUM, is that based off on your original lease purchase? Our lease of that ground, if I'm leasing that state section, I'm entitled to take 35 AUMs off of it. And just for round figures, it's $2,000 a year. Okay. So if I'm going to enter into subleasing it, would that just be the additional 1/2 or an additional $1,000 per season on that, for that 35 AUMs that I would be subleasing? Does that make any sense, or?
Senator Hicks.
Madam Chairman, I may have to phone a friend here, but I believe all state grazing leases are rated on the number of animal units and not the acres.
Right.
So that's already the scenario. So you're not leasing or subleasing acres. It's all predicated on the number of AUMs off of that land.
Okay.
I'm looking for a nod. Yeah, got.
All right.
Okay.
All right,
Thank you.
any further comment or questions for Representative Davis? Seeing none, any other legislators? No. Seeing a no there, now we'll go to the stock growers.
Thank you, Madam Chairman. Jim McGagin with the Wyoming Stock Growers and also on behalf of the Wyoming Wool Growers. Rather than repeat testimony I've given previously, I'll try and address some of the issues that seem to have surfaced here at this point in time. One of those has to do with the subleasing, and I think that's been explained by Representative Schlegel pretty well, the difference between these two things, where I'm just bringing livestock in. And I guess the best example I would use, if I run my own livestock and I make $10 a head when I sell those livestock, there's nothing says I give half of that to the state. There's nothing in the Constitution, there's nothing in law that says I have to share any gains I make from grazing the state lands. If I run somebody else's livestock, but I'm responsible for them, I'm using the forage in the same manner that I would use them with my own livestock, I'm accountable for it, then our position is that there shouldn't be a sharing with that. Now, having said that, One of the biggest complaints I hear from lessees out there is not so much necessarily just that they're sharing a share of some gain, but the process they have to go through. They have a private contractual relationship with the person that owns the livestock. They're being required to share that with the state and demonstrate to the state how much money they made through grazing those unknown livestock. And it's for that reason, we would certainly agree with Madam Chairman, with your earlier comments. Why should they have to pay anything? Because they're grazing them land in the same manner, whether it's their livestock or others. However, we're willing to agree to this surcharge that's spelled out in the proposed language, simply because that gets out of having to go through those very complex calculations, sharing private information. Should they have to pay it? We would believe not, but would they be willing to pay it, a reasonable surcharge? And we would see that as being based on, from the number of AUMs that they actually grazed on the state trust parcels, what percentage of those AUMs were grazed by non-owned animals? 50%, 100%, 10%, whatever that percentage would be. Of the AUMs that they harvested times a flat fee that the board would establish is what they would pay for the sort of the privilege of grazing someone else's livestock, even though the real impacts are not any different. And that's why we would prefer a formula, a flat formula like this, a flat fee over the complications that exist with that today. Just to address one other question I believe Senator Hicks raised, as we read the language that's been provided here, shall not be required to obtain the approval of the director to allow livestock the lease does not own. That shall only applies to approval of the director to run livestock they don't own. All the other provisions that are in statute with regards to meeting the terms of your lease, paying your annual rentals on a timely manner, managing the lands in a manner that cares for them, et cetera. All the other things that could result in the loss of a lease remain in place, whether you're running your livestock or someone else's livestock under this particular sub-provision. So we think that part is covered. The last thing I would mention, Madam Chairman, with regards to the language that was added here at the last moment about saying full management responsibility, we had proposed that the board would define that. This now proposes to define it here as including all duties, obligations, and liabilities as if the livestock were owned by the lessee. Have some concerns with that because there are duties, obligations, liabilities related to, does that make me liable if an animal dies while they're on the property? Well, that's subject to what agreement I have with the other third party that owns the livestock. It shouldn't be a part of this. So we were fine with letting the board define the meaning of full management responsibility, but we're also fine with the legislature doing it. I would suggest for your consideration, having just looked at this, that perhaps include all duties, obligations, and liabilities related to the management of the livestock while on the state lands. So that we're not talking about unrelated duties and responsibilities that don't pertain to this, that would be a way, if you committee desires to keep that language in there, to put that limiting factor on it, that it's, I have a duty and a responsibility to load the livestock when they're being shipped back to the owner. I don't think that's what you're envisioning here or any other things. So a qualifier there would be, in our view, a way to make this language work. With that, Madam Chairman, I'd be happy to entertain any questions.
All right, questions from the committee. Questions, Senator Hicks?
Yeah, Jim, the question is, so when you have your own livestock, you're marketing whatever that product is, beef, yaks, sheep, whatever that is. And so when you have an arrangement where you're running, say, yearling operation, which is not uncommon in my country and stuff, you're not marketing your grass, you're using your grass, but you're effectively getting paid to market your ability to manage those livestock. Would you agree with that or not?
Madam Chairman and Senator Hicks, you're getting paid for the forage that they're consuming, and you're getting paid for providing the management of the livestock.
So you're getting paid twice then. one for the forage, that's part of it, and then also for the management component. Because you wouldn't enter into a contract if you didn't have the ability to manage those and make a profit off of them. Well, I shouldn't say that. I've got friends that haven't done too well.
Madam Chairman,
on a
Sarah
couple of those
Hicks, you
contracts.
don't always make a profit off of it, certainly, and there are a number of factors that cause you to bring in livestock. It may be because of drought, you had to get rid of some of your own livestock. It may be, as you have referenced, some people, yearling operations, that they found that to be more favorable to them. But the key in terms of the state land is that I'm using the state land in the same manner, with the same care, under the same obligations, whether I'm using them with my livestock or with someone else's livestock. And while I don't make a profit every year on my livestock, I can assure you from having visited with numerous people that bring in livestock, whether it involves state land or just on private lands, they don't always make a profit there too. The one advantage of having this flat fee determined in advance would be that then, as a landowner and the state lessee, if I'm putting together a proposal as to under what terms I'll accept your livestock, I can build that into it in advance because I know what I'm going to have to pay to the state for it.
And that makes all the sense in the world to me from a standpoint. You have to do that if you're going to contract to run somebody else's livestock and you have full management authority. You got to calculate in that into your profit margin.
That's correct.
All right.
Mr. Senator Higgs.
Thank you.
All right. Senator Ide.
Thank you, Madam Chair. Mr. Magagna, yeah, I'm still struggling with this. We've got this Romanet 4. It says, state land grazing on state land shall not be required to obtain approval of the director to allow livestock the lessee does not own. And then, we go to J on the next page, and that contradicts that a little bit. It's just saying that effectively you do, because if you do, there's a surcharge. And I don't know how those two mesh together. That's where I'm struggling with the language on this. Thank you, Madam Chair.
Madam Chair, Senator Ide, the way I would separate those two is that what it's saying on page 1 in little 4 is that you don't need prior approval. If I decide halfway through the grazing season to bring somebody else's livestock on, I can go ahead and do it. The intent of item J on page 2 is to say, I don't have to have approval to do it, but I do at the end have to report that I did it after the fact in order that the office is aware of it, and in order that I can include the fee that's been offered here. So the way we would, this would be up to the rules that the board would make, but the way I would at this point envision this could work, say when I pay my annual rental, and on that form that they advise me I have to pay my annual rent, there could be a line on there that says I did or did not graze unknown livestock. And if I did, I estimated that they grazed X number of AUMs on the state land times the fee, and I've included that amount in my annual rental payment. So it would be an after the fact reporting and paying rather than having to know in advance what you're going to do. You may bring some livestock in halfway through the season or something. And that's the other thing I hear a lot from our members is that sometimes these arrangements happen on the spur of the moment because someone desperately needs a place to put 50 head of cattle and you can accommodate them. And if you have to go through the process of getting a prior approval from the Office of State Lands, which is what you have to do today, that becomes quite an obstacle to being able to move forward in a viable manner.
All right. Okay, any further questions? Seeing none, thank you very much.
Thank you very much.
Appreciate it. All right.
Public testimony.
What's that? Yes, other public testimony will go in the room, and then when we're finished here, we'll go online. If Laura Pearson, she is not online. Okay, welcome, Ms. Herman.
Thank you, Chairman Steinmetz and committee. Marguerite Herman, I'm here. Wearing my hat as for the advocates of school trust lands, and I spoke to you when you worked the bill the first time, and in your absence, and Chairman French did a great job. I would just have to say, just to start out with, because we're highly aware, sensitive to the point of these lands, which is, and the point of the administration of these lands is to produce revenue for public schools under our active admission and Constitution. So I won't beat that horse again, but just to say that I understand also that in Wyoming, the legislature, not all western states, but others like them also, want to make the trust lands available to surface leases, wind farms, ag, all kinds of purposes. And I think agriculture, there's a sense of, making it a little easier to access the lands, and because we value our ranching operations. So, and to me, I kind of think, okay, but there's a line across which, and so where that access compromises the revenue producing thing. And I think this has kind of set off some alarms in my head. And when I was reading the amendment, again, just recalling very briefly what Mr. Crowder told us last week about this, what's it called again? I'm sorry, the parity ratio, which is the first cut taken on the AUM grazing lease amount. That's the discount based on the risk taken by the owner of the cattle, in this case, the lessee, so that so you get the quality forage, and then you take this discount, a 66% discount. So it's a pretty deep discount, but again, recognizing the risk taken by the owner of the cattle, and in the subleasing. That whole thing is removed, and I can sense that idea of how to make that equal and compensate for it with a surcharge, again, a flat fee, which is the Board of Land Commission is supposed to come up with a fee that fits all different situations. I would say that's going to be a tough thing to do, and make it pass constitutional muster. I know the House bill sort of said this is not a sublease, but I think that might be a difference of opinion. And also, and the other sort of vague things that kind of give me just a little bit of heartburn about the amendment is you must be reasonable. And what is that? What is the surcharge? How is it figured? And then management of, it has to be, they're substantially managing the cattle. And what is that? How do you manage management? And how do you measure it? How do you define it? Who polices that? Who says, well, no, who goes on the land and says, I don't think actually this is accurate. And really getting back to that parity piece, just make this an arm's length agreement and take away that discount. And then all of a sudden it becomes market value for the forage. And I think that is sort of, I know we're trying to wind our way around being fair and accessible and yet producing revenue. And that to me is the simplest. There's some kind of an elegance about doing that. Just take away the parity ratio. The lessee is not the one who is needs that discount. It's not his or her cattle. And so that makes it kind of, I think, a cleaner bill. It just occurs to me that would correct for all the things we're trying to correct for. But as the discussion tonight, it's a complicated thing with a lot of moving parts. And I know that I suggested last week, I'll just renew my suggestion that maybe this is an interim study to weigh all those things. But I guess I would just say that, and I don't know if you have this from last week, but one thing about it that's sort of interesting is that when you take away the parity ratio, you end up with what is considered a reasonable return. I think it would be $16.33 per AUM, and that's the market value. And you still get the discount, the 20% discount for the cost of running the operation. But that parity ratio, I think that's what sort of sets this kind of going down one path, and then all of a sudden it's switching. And if we don't do that, I think it does address the problem. It's clean, and you're not correcting for things, you're not surcharging to make up for things, and that's would be my suggestion, and that would preserve as the trust fiduciary responsibility, and allow the lessee to run someone else's cattle and not have to worry about how much management is management, and then, terms of art and that sort of thing. And I stand for questions or
All
sit for
right, I
questions.
think you have one. Senator French?
Thank you, Madam Chairman. I think a person's got to remember that many of these ranches, these state leases are not fenced. So maybe they have 100 AUMs and they're paying $550 or whatever it is per AUM. So let's say they are paying the state $550 for that piece. Their cattle may, in a certain year, may never use it at all. So the state's getting $550 when they shouldn't have got $550. You see what I'm saying? Where they may have just walked across that state lease and grazed across it quickly. They very well may not be using their AUMs, maybe just a small portion. So that's something to keep in mind too.
Further questions for Ms. Herman? All right, thank you for your testimony. We appreciate it. All right, anyone online yet? Seeing no one, anyone else in the room? Seeing none, we're going to close public testimony. Committee, what is your pleasure on the bill?
I'd move the bill.
Moved by French. Do I have a second? I'll second the bill. Moved by French, seconded by me. And so let's talk about the bill. Are there any amendments on the bill? Senator Hicks, I know this was your amendment that you worked hard on.
Madam Chairman, I think I adopted this amendment, but I can walk you through the amendment real quick. This
Walk us
tries-
through your
It
amendment.
just tries to get to the issue that we're dealing with. The meat of the amendment, it brings in this new subsection D, changes some of the additional language there as far as the assignments of the sublease approved by the director. Mostly that just cleans up the language there. Romanet I, again, it's just clean up. Approval shall not be arbitrary or unreasonably withheld. Romanet II, again, that's more cleanup language than anything. Romanet III is existing language on subleases where half of the excess rental is paid to the state. And then really the meat of the amendment is Romanet IV. And then it goes over to page 2 with subsection J. And then subsection 2 is we bring that back. And that just says the land commissioner shall promulgate all rules necessary to implement this act. And then the effective date, Madam Chairman, that's what this amendment does. I would move the amendment.
The amendment's been moved by Hicks. Do I have a second?
I'll second.
Seconded by Kolb.
So, Madam Chairman, just for discussion, and I do think there is an outstanding legal question, and the way I read this, if we go down to Romanet IV, I think we put two obligations in here when we say that the leasee of state lands whose lease authorized grazing on the state land shall not be required. And the shall, I think, is problematic because I think it does create a legal conflict with Romanet D. And then I think it also, when you get over to subsection 2, and it says the State Board of Land Commissioners shall promulgate any rules necessarily to implement this act. Under the language there, they can't promulgate any rules because it says they shall not. So I think it puts a conflict with the job, the duties of the director. And I think it restricts the land board from being able to promulgate rules that may say in the case of violations or the case of catastrophes. It could be wildfires. It could be grasshopper pandemics that they're just going to have to issue this lease irregardless of any of those circumstances. So my suggestion would be to strike the word shall and insert may, Now, I know that the land board and the director understand what the intent is, but you have to have, in my opinion, that little escape clause for those circumstances, as I described, maybe, catastrophic wildfire takes the lease out, or whatever that is, the lease violation. I just think you have to leave that in there as a may instead of a shall. That would be my suggested amendment to the amendment, Madam Chairman.
All right, discussion on the suggested amendment to the amendment. Senator Ide.
Thank you, Madam Chair. I may disagree with good senator sitting next to me here. I like the language actually in Romanet 4 with the shall, but then I don't know how you deal with that subsection J back there, because I think it's too arbitrary on the reasonable surcharge, and I think those two, Romanet 4 and subsection J conflict with each other. That's my personal opinion. It's almost like just take subsection J out. And it sounds like it's more on the honor system anyway, as far as, them, if they're doing something that's not in compliance with the state land office, they should report that at the end of at the appropriate time to settle up to pay their 50% above, what they're paying right now. So that's where I'm struggling with this. Thank you, Madam Chair.
All right, further discussion on the amendment to the amendment of changing shall to may. Discussion, seeing none, I do have a little of that same reservation. I think that shall not be required to obtain approval. On the front end is important to me to see that stay in, so I'll probably be a no on that as well. And then I might have some other thoughts about how we clean that up a little bit. Further discussion on the amendment to the amendment? Seeing none, all those in favor of changing shall to may, please say aye.
Aye.
Opposed, no.
No.
The motion has failed. I'm a no, so it will stay shall. One thought I had, committee, is maybe adding after the lease on line 28 of the amendment, a lease of state lands whose lease is paid and in good standing. Maybe add that in some form. That may not be the exact right, because then it says authorizes grazing. Whose lease is paid and in good standing is authorized. We can work on that, but I thought about adding the concept of a lease that is paid and in good standing, so that we're not talking about, you have to be paid and in good standing to be able to utilize this feature. If you're not, then the other provisions of the law would apply. For discussion, I'm throwing that out there.
Yeah, Madam Chairman, I don't know that would capture, I don't know that would capture all the potential cases. And so you could be in good standing and still violate the terms and condition of Romanet 4. In other words, you're no longer managing, you just turn around and lease and that may be recaptured up in subsection D further up there, but I'm just thinking you may end up in a situation where there needs to be an enforcement action taken, and it has nothing directly to deal with the lease being in good standing. In other words, the lease fee's been paid, the paperwork's been filed, but something else could transpire that would be outside the bounds of Romanet 4, and then I don't know that you could come back and, just because if you bring that language in, I think it would help, but I don't know it resolves my concerns.
All right, thank you, Senator Hicks. I may bring that from the floor if I can figure out a way to do that, so I won't make that as a motion at this time. Are there any further motions to amend the amendment, which has basically become the bill? we did have a suggestion from the stock growers to add after liabilities on line 35 related to the management of the livestock while on the state land. So that was one suggestion as well. Any thoughts on that? All right, not seeing anyone take her there. Senator Ide.
Just back to this subsection J, just trying to get the, that reasonable surcharge. I don't know if there's some language in that, I'm maybe out of turn here, where I'm just
No,
talking
go
about
ahead.
to determine what that surcharge or that fee would be in the formula, so you kind of knew if you cross the line, this is what it's going to cost us, sort of an issue. And that's about the only part I'm struggling with this amendment here. Thank you, Madam Chair.
All right, any further thoughts on that? Any further amendments to the amendment? Seeing none, we'll vote on the amendment unless there's further discussion on the amendment. Further discussion on the amendment? Seeing none, all those in favor of Senator Hicks's amendment, say aye.
Aye.
Opposed, no. The amendment has passed. Linda, have you got all of that? All right. So that, with that amended, is there any discussion on the bill as a whole, which this basically is the bill now, as it's reworked? Seeing none, Linda, would you please call the roll?
Senator French,
Aye.
Senator Hicks,
No.
Senator Ide,
Aye.
Senator Kolb,
No.
Chairman Steinmetz.
Aye.
Would you like me to carry this on the floor?
No.
Madam Chairman, and I will follow up with our staff attorneys, and if they can alleviate my concern of the shall versus the may, then certainly I'd probably can lend my support to it, but I still think that, in my own opinion, that creates a legal conflict, and I don't know, but let me follow up, and we'll see what we get from the attorneys on that.
All right, well, I think it's important we get this bill out of committee. And so we can, if there's further amending to do, we have 3 readings on the floor. So with that, is there anyone who would volunteer to carry this bill on the floor? Seeing none, I will do it myself, and we will see where it goes from there. All right. The next bill for our consideration is House Bill 11. State Park Rangers retirement. Welcome, Representative Washut.
Thank you, Madam Chair. I think this is my very first time before Senate Agriculture Committee. So,
Well, you're in for quite a treat then. We're glad to have you. Go ahead and take it away.
Can you get him to move over to the hot seat? Swap. Get him in the hot seat.
No, he can sit where he wants. All right, go ahead.
Madam Chairman, Committee, I bring you House Bill 11, a bill which Senator Kolb and I both were part of working over the interim and as a joint judiciary bill. The bill is actually fairly simple. What we have is a small number, 4 or 5 state park rangers who have historically been part of the big retirement plan in Wyoming. And this bill puts them into the law enforcement plan where they more properly need to be. Our state park rangers are full sworn peace officers in every sense of the word. They're certified by the Peace Officer Standards and Training Commission. They enforce criminal laws just like all of our other law enforcement people. You might remember that about a little over a year ago, we had a state trooper shot in Sinks Canyon up above Lander, and the first officer on scene to assist that trooper was a state park ranger. They are full-fledged law enforcement people. So what we're trying to do in this bill is put these law enforcement officers into the plan with other law enforcement officers. So if you look through your bill, we start off with the purpose of the bill on page 1. We start getting into some of the meat on line 13 of page 2, where we add full-time state park rangers to that litany of other law enforcement personnel identified in the statute. Then we move into 93432 at the bottom of page 2, where we include in the definition here, any full-time state park ranger who is employed as a full-time state park ranger before July 1, 2023, and who elects to continue participating in the Wyoming Retirement Act as a general member. For some of these, at least one of these park rangers, they have been in that big plan long enough that it would be financially ill-advised for them to switch to the law enforcement plan at this point. Then going down into page, the bottom of page 3, section 2, again, we just start talking about the coverage process of electing to be in or out of the plan. So there are other people in the room here who can offer you a lot more in terms of the history of how our state park rangers ended up not being included in the law enforcement plan, and what the financial implications of moving them from one plan to the other might be. But with that, I would stand for questions or refer you to the other witnesses.
All right, any questions for
Yeah.
Representative Washut? Senator
Madam
Hicks?
Chairman, Representative Watcher, or any of the other panelists, and I know, but for the edification of the committee and the audience, describe what the fundamental difference is between the large plan for state employees and then law enforcement. And it's really about time of service. But just describe what those differences are so the committee knows what those are.
Director, you want to field that one?
Madam Chairman, I'll try. Darren Westby, Director of State Parks and Cultural Resources. First, thank you for bringing this to your committee. I don't, like the representative, we don't get in front of ag very often, and I learned a lot about AUMs and leases and subleases and all that. So hopefully we'll have the opportunity to give you some information and let you learn a little bit more about our law enforcement as well. And so I believe you're correct, Senator Hicks. It's a year time served as in this profession. You get to retire a little bit earlier than a normal. There's also the state pays, I believe, fully into the system for the employee, as opposed to in the big plan, as the representative calls it, the big state employee plan. There's a percentage difference. I think the state employee pays 3-ish% versus the employer pays the rest of the amount. And I know we have Mr. Bleakley on possibly online that can help with some of those definitive terms with the Wyoming retirement system, if there's any other actuarial impact questions that come up. But did that follow what you were trying to get at, Senator?
Yeah, I think the big differential is, and I can't remember the exact, but on the state plan, I think it's got the, what is it, the rule of 88. You have to be 58 or 30 years of service or whatever that number is. And to be fully invested and eligible in the law enforcement plan, it takes 20 years and you're eligible for full retirement. So it's a length of service is the big fundamental difference between the program. And I think you're right. There's a little bit of a differential. It's not substantial in the contributions from the employer and the employee. I think my recollection is it's just a little higher contribution for the law enforcement plan than it is for the big plan.
Mr. Chairman, I'd like to introduce our Chief Ranger, Mark. He probably has the numbers exact as well.
Madam Chair and Senator Hicks, I'll defer to the retirement program to make sure we get the exact numbers to you. But one of the benefits is in line of duty death benefits as well. That's important to our officers. That's a big distinction. So make sure that our officers, we had an officer shot in line of duty assisting Platte County in about 2015 on a call to assist them. And you know, our rangers are the only law enforcement oftentimes in our parks because, you know, the resources around us are so limited. around the state that we respond a heck of a lot more to calls for assistance for other agencies than, again, times we ask for assistance. So that puts us, we function as a peace officer in the state of Wyoming, like any peace officer does. And we're just asking to help take care of our law enforcement officers like every other law enforcement agency in the state.
All right. Any further questions? Questions from the committee? Seeing none, stick around, but we will go to the agencies online. It looks like
Mr. Chairman,
Mike
Madam Chairman,
Bleakley from the retirement system is online.
I do have one question.
Okay,
in here,
go
and
ahead.
so- and
Why
I-
don't we, hang on just a second, why don't we get Mike online in case there are questions he could answer for us? And once he's there, Senator Hicks, you can continue on. Would that be all right?
Fine.
All right, welcome to the Ag Committee. Thanks for being with us. All right, go ahead, Senator Hicks.
Yeah, and this has nothing to do with WRS. And so the law enforcement officer gets to determine whether they want to keep the plan or transition over to the law enforcement plan. But, and it's probably in here, but we can't just leave that open-ended. So when does the decision have to be made to transition? If somebody can answer that and point that out in the bill. it
It's a
would be helpful.
one-time option.
Yeah, but
When,
when?
once they decide, they're either in or out, but the date, the director.
Yeah, Madam Chairman and Representative Wassett, and I get it, they get to choose one time. But is it 2 years from now or 3 years? And that's what I'm trying to find in the bill is when does that choice have to occur to opt in or stay where they're at?
Madam Chairman, Senator Hicks, on page 3, section 2, it says not later than April 30th, 2023. That decision has to be made by our current 5 law enforcement that we currently have right now. They have until April 30th, 2023 to make that decision, either to enter in or stay with the large plan.
So roughly 6 weeks from the time that the governor signs the plan. I'm assuming it's effective immediately. Yep, all right, thank you.
All right.
Madam Chair.
Further questions, Senator Ide?
Just a quick question. Why would somebody choose to stay in the plan and not switch? Thank you, Madam Chair.
Director.
Madam Chairman, thank you, Senator Ide. One reason would be if they're already a retired peace officer. Say we have an individual who is on his second career and retired from the Laramie County Sheriff's Department, and we were fortunate enough to hire that expertise in his second career as a state park ranger. Them going back into the law enforcement program is counterproductive for him as a law enforcement agent. He would stay in the Wyoming retirement system and start generating his second retirement in that form. Or as Representative said earlier, is it may not be financially advantageous because they're already pretty close to the Rule 85, and switching plans right now wouldn't help them.
All right, further questions? Further questions? I have one. And so say some of your officers retire and you hire new officers, would they just automatically go into this plan? All right, okay. All right, well, thank you very much. I don't see any other questions. Do we have any testimony from you, Mike, online from the Wyoming Retirement System? Is there anything you'd like to share with us today?
Great. Thank you very much, Madam Chairman. My name is Mike Blakely. I'm the Deputy Director for the Wyoming Retirement System. And I just wanted to thank my colleagues in the room. If they're looking for a job at retirement, they're getting those questions answered pretty good. So I appreciate that very much. Just so you know, to Senator Hicks' question, Madam Chairman, the contribution rate for the public employee plan, which is the big plan, is 18.62. And the contribution to the law enforcement plan is, I just had it here. It's 17.2. So those are the contribution rates. The big difference between the two plans, as was already alluded to, one is the enhanced death benefit, but there's also the multiplier. So if you're in tier 2 hired after September 1st of 2012, if you're a teacher or a state employee, your multiplier is going to be 2% per year of service. For law enforcement, it's 2.5% per year of service. So it is a better benefit. And you also can retire after 20 years of service, where in tier 2 of the big plan, it's rule of 85 or age 65. So you can definitely retire at a younger age. The reason for that provision is, you know, people who are dealing with the public, sometimes as all of us get older, it's harder to be in a position to chase someone down or do some of those activities that are required from law enforcement. So usually you see public safety have a younger retirement age. And with that, I think they've answered all of the questions. So unless you have any other questions for me, I appreciate your time.
Thank you very much. Before we go to any questions, I want the committee to go to your bill and go to the last page in the fiscal note. And that is where you will find all of what Mr. Bleakley has been speaking about. So if you go to your bill, the last page is the fiscal note. You'll see in the second paragraph, there's the reference to the 17.2 and the 18.62. And so that's where that is found. And in looking at that, does anyone have any further questions? Further questions? All right, thank you very much for your testimony. We might have you stick around just in case there might be more. With that, no further, go ahead, Representative Washut.
Thank you, Madam Chair. Just on the fiscal note, there is a slight amount of money that's required to basically balance the books. Mr. Bleakley could probably explain that a little more detail if you need it, but we're not, do you see the fiscal note doesn't include the entire cost of the pension because these folks have already been in a pension. It's just the difference between the two plans that needs to be made up in the fiscal note.
Representative Washut, is that the $5,254?
Yes, Madam Chair.
All right, thank you very much.
Madam
Did you
Chairman,
have something, Director? Go ahead.
just along the same lines as Representative Washut, the difference of moving these individuals into the law enforcement plan is the 186 down on paragraph 3, the
Okay.
186,000. The ongoing effect in our budget, the benefits line within our budget is the 5,254 per year, so a little over $10,000 in our general fund budget that would end up being biannualized in our standard if this goes forward.
All right, okay. All right, any further questions, Senator Hicks?
Yeah, Madam Chairman, and just for full disclosure for everybody in the committee, and that's likely to go up. This is an interim topic for the Appropriations Committee to take up because the law enforcement account is trending downward. This isn't going to change the trajectory one iota by adding 5 people to it, but the fact is it's not moving in an actuarially sound direction. It's already an interim topic for the Joint Appropriations Committee, so that cost is going to have to go up. In other words, there's going to be an increase in contributions by probably the employer, at least for the state, because we pay 100%. But keep in mind, the local governments that participate don't pay 100%. So that's always an issue out there. But one way or another, the 17 point whatever it was is moving the plan in the wrong direction. And so it will be a slight increase going forward as we make those adjustments in the next year that I fully anticipate is going to happen. Your retirement plan, it's incumbent upon all of us to make sure it's there when those folks retire. So anyway, just you'll remember this discussion, Madam Chairman. You were on appropriations then. So anyway.
All right. Go ahead.
Madam Chairman and Senator Hicks, thank you for bringing that up because we heard that both Chairman Washut and Senator Cole, you heard it, Senator French possibly too through the interim discussion through the judiciary. The actuarial discussion was very, very important conversation, and we had the director and deputy director there as well, and they had very good conversations about the need and the why. I guess from our perspective, it's an equity thing. We have true law enforcement individuals working for me, and probably 10, 15 years ago, before I was in this position, they tried a run on getting these people in, and it was unsuccessful. I think their reasoning behind that is we were trying to bring our superintendents in that had law enforcement, and so we really scaled back. After I had an aha moment when I became this position, and Mark got on the job and started research, and he asked, why aren't our law enforcement in the law enforcement retirement plan? And I said, I thought they were. And so that fell back on me to put forward that interim topic, and gratefully the judiciary brought it forward and had great debate and conversation, and it obviously what you see today. And so from an equity perspective, adding these 5 people into this protection plan for these individuals is long overdue. And that's my opinion, and but I'm sticking to it. I feel embarrassed as a director of an agency that has law enforcement that I didn't catch this sooner, and I appreciate your opportunity to listen and go forward with it, because these individuals, if you look at in your area, Glendo and Guernsey, Glendo on a regular busy weekend is 30,000 people. And we have 2 law enforcement, 1 full-time and 1 part-time. That's a 5th largest city in the state of Wyoming on a weekend, and
Madam Chairman,
they do their job.
Senator Hicks, go ahead.
I think you got it, but you're getting dangerously close to talking yourself out of. So,
Never
Madam
talk your bill
Chairman,
to death.
without any,
All right.
with all due respect here, I think this is a good idea. We should have done it a long time ago. I move the bill.
Thank you, Madam Chairman. Committee.
Senator Hicks, we need to have public comment first.
Oh, yeah.
All right. Okay, thank you, agency personnel. We appreciate you being here tonight. Is there any public comment in the room? Any legislators wishing to comment? All right, anyone online? It looks like we had Byron Odakoven from the Association of Sheriffs and Chief of Police. All right, so we'll let Byron in. All right, welcome to the Ag Committee. Go ahead, Mr. Odakoven.
Thank you, Madam Chair. Byron Odakoven, the Executive Director of the Wyoming Association of Sheriffs and Chiefs of Police, rising in support of the bill for many of the reasons that you've already heard, and reinforcing the idea that these are full peace officers as defined by statute, covered by the Peace Officer Standards and Training Committee, and in many cases are our former officers who moved over, or in some cases where we recruit from, Madam Chair. So these are our equals, our contemporaries, and their benefits should be equal as well. So that for the most of the reasons mentioned, whether it's liabilities, whether it's death benefits, injuries, or full retirement, they should be included in the retirement bill and legislation, and would stand for questions.
All right, questions committee, questions from the committee. Thank you, Mr. Odakoven. Have a good evening. Appreciate you being here.
Thank
All
you.
right, with that, we will close public comment. Committee, what's your pleasure on the bill?
Move the bill, Madam Chairman.
All right, moved by Senator Hicks. Do I have a seconded by Senator Kolb?
Second for the second.
All right. Any discussion on, any amendments on the bill? Amendments on the bill? Seeing none. Any discussion on the bill? Discussion on the bill? Seeing none. Linda, would you please call the roll?
Senator French.
Aye.
Senator Hicks.
Aye.
Senator Ide.
Aye.
Senator Kolb.
Aye.
Chairman Steinmetz.
Aye.
There are 5 ayes. No.
5 ayes, the bill passes. Senator Kolb, did you want to carry this on the floor since you worked in the interim?
I can, yes.
Or did you have someone else,
No, I can.
Representative Washit? All right, you're assigned.
Why, thank you.
All right.
Don't screw it up.
that concludes our bills. We have a few housekeeping items. We will be meeting Thursday night, February 23rd. Thank you all for being here. And we will be considering House Bill 222, Colorado River Advisory Committee, House Bill 76, Licensing Board's Amendments, and House Bill 171, State Land Leases. We will also try to take up our interim committee topics that evening. Hopefully, we can do all of that at the same time. If not, we'll try to reschedule another time for our interim committee topics if we get too tired. With that being said, interim topics are due February 24th. So please get those in so that we can have a good discussion about those. With that, there is one more thing on Thursday morning at 8 a.m. where everyone's invited to go hear the FFA students present in the House Ag Committee room. They're doing an FFA presentation, their mock session of a trial, and Karen Bud Fallon is the one who's coached them on that. That's always a treat. So if anyone would like to join for that, it's a good thing. So it is Thursday at 8 a.m. Any further discussion from the committee on any subject?
Madam Chairman, when are we doing the forestry hearing with the Forest Service?
The state forestry briefing is the 28th at 1 o'clock over our lunch hour. And so they'll be coming, and Linda has sent out one notice of that. We'll notice it some more, two notices now in the following days. We've asked everyone to mark their calendars because I know it's a big event. So, all right, with that, if there's nothing further from the committee, we are adjourned. Thank you.